Hi, and welcome to the show. Subscribe at kevinmd.com/podcast. Today, we welcome back Muhamad Aly Rifai. He's a psychiatrist and internal medicine physician. Today's Kevin MD article is The Criminal Enforcement of HIPAA. Muhammad, welcome back to the show.
Thank you for having me talk to your audience about HIPAA, the Health Information Portability and Accountability Act.
All right. What's this article about?
So in the article, I talk a little bit about the history of HIPAA. So HIPAA, the Health Information Portability and Accountability Act, was passed in 1996 by Congress. And since its passing, which was mainly passed to facilitate the transfer of electronic medical record while maintaining patient privacy, it has morphed into a burden on practices, especially private practices. And over the past few years, we have seen that actually it has become a meaningless and a toothless piece of law that has not helped people keep their information private. With the HIPAA law, there's a companion code of federal regulation, a law 42 USC section 1320-D6. Now, this part also imposes criminal penalties on individuals who violate the HIPAA law up to 10 years in prison. Now, over the past few years, the cost of maintaining HIPAA and the electronic medical record have skyrocketed. But we have seen also a new phenomena. We have seen kind of continuous and unlimited number of breaches where individuals, hackers, cyber criminals, utilizing the ransom technology, basically gather a large amount of information, health protected information, private health information that basically they sell out on the black market. And not one day now passes where we just don't hear some information, a hospital, health insurer, some medical company that got hacked with information about many Americans kind of being out there. So that's been problematic.
All right. So before we get into some of the problematic issues with HIPAA, just give us the overall intent in terms of why HIPAA exists in the first place.
So HIPAA existed basically to facilitate the transfer of electronic medical records. It pertains specifically to electronic medical records between providers. Basically, the insurance products and the fact that people change jobs from one insurer to another. Congress in 1996 wanted to ensure that when people changed jobs, they were able to transfer their medical information with them. And with the advent of electronic medical records, they wanted information to transfer very easily. And we have seen some of that happen. For example, the largest electronic medical record system in the country, Epic, information flows very easily between different hospitals and different organizations, and people to a certain degree are able to basically move their electronic medical records from one provider to another. But the implementation of that has been burdensome. There's been a significant expense associated to private physicians. Hospitals have been able to defray that cost, but it has been a significant burden and has not been helpful to physicians and has not been helpful to patients.
So tell us the impact of holding people who violate HIPAA criminally responsible. What's the impact of that on the medical profession?
So we've seen basically that HIPAA implementation has always been very minimal implementation. So any inadvertent mistakes, for example, with disclosure, for example, sending the medical record of a patient to the wrong physician. Basically, that's inadvertent disclosure. Or inadvertent disclosure, for example, a patient calls or a patient's family member calls and the patient does not want the family member to be involved in their care. And sometimes there would have been a permission in the past and the permission was revoked. So inadvertent disclosure of some information. And those all are dealt with civilly. Mm-hmm. But we have seen some situations where some of these laws were deployed toward physicians who made inadvertent errors and mistakes. For example, a physician, an obstetric gynecologist physician in Massachusetts. She was prosecuted because she failed to obtain a business associate agreement when she had a pharmaceutical representative assist her office in prior authorization, which is a normal practice sometimes, specifically that prior authorizations for medications or treatment or devices sometimes are pretty complicated, and the involvement of pharmaceutical representative can facilitate that. But however, she failed to obtain a business associate agreement with that pharmaceutical representative, and she was prosecuted criminally. The judge was very kind to her, and he spared her jail time, but the government was asking for 5 years in jail, and she basically was spared jail, and she is back in practice, thankfully. But people could be prosecuted criminally very, very easily.
Now, what kind of changes do you think are needed in terms of HIPAA enforcement to ensure that patient information remains protected, yet not over prosecuting those who potentially violate it?
I talked about the fact that the largest holders of electronic medical record information for patients in the United States are health insurers and hospitals. Not one day passes where we hear about a hospital that was hacked, a ransomware. I can tell you about a difficult experience that a local hospital in my area went through. A local hospital acquired a hematology oncology group, and during that acquisition process, some glitches happened in the security of the electronic medical records, and the electronic medical records of that hematology oncology group was hacked. A ransomware was taken, and the hospital actually refused to pay the ransomware. And the hackers actually ended up releasing some of the information, and it was quite unfortunate. Some of the information included pictures of patients, cancer staging pictures of patients who are unclosed, and that was quite harsh to the patients. However, the hospital did the right thing. The patients filed a class action lawsuit against the hospital, and the hospital owned up to their mistake, and they actually settled the class action lawsuit. Most recently, my practice has been a part of that. Change Healthcare, which is a large biller processor in the United States that became part of United Healthcare, was hacked, the largest hack in the healthcare history. The data of 191 million Americans is out there, including my own data. I know I was a patient in a practice that had Change Healthcare, and I know now all of my data is out there on the dark web for somebody to buy. If somebody's watching this, probably it's about 70–80% chance that their data is out there too. And we haven't seen any ramification for what has happened. It's been about a year. There has been no ramification. It's mostly like nothing to see here, folks. Just move on. 191 million Americans' data, names, social security number, addresses, medical history, private information, including electronic medical records that were sent to the insurer to justify care. All that is out there somewhere for hackers to exploit, and we haven't seen any response. The entity that actually enforces the HIPAA is the Office of Civil Rights in the Department of Health and Human Services, and we haven't seen any action. And they usually, if they're going to treat this as a civil or a criminal case, they're going to coordinate with the Department of Justice, and we haven't seen anything with the Change Healthcare significant hack.
So you clearly articulate a disparity when it comes to HIPAA enforcement. They tend to target individual physicians versus large organizations like hospitals and insurers. Like you said, with the Change Healthcare leak, they, as far as you know, didn't get any type of punitive action from those who manage HIPAA. Why do you think that is? Why do you think that the enforcers are targeting individuals rather than large corporations?
I think it's very hard. Individuals, physicians, we basically are very easy to prosecute, get penalties from. Large hospitals, large organizations, they have large groups of lawyers who protect them, who will drag legal proceedings. and will fight government lawyers who are seeking to get penalties. They will appeal. They will take it to the Supreme Court. It will come down. They will appeal again. So basically, it's just the cases will be defended, and it's only us physicians who are on the front line where there is inadvertent errors sometimes that things happen. Now, there is also an unfortunate event that happened over the last couple of years also, where criminal HIPAA violations sometimes are politicized and the criminal justice system is weaponized for political reasons. So a surgical resident in Texas, Dr. Eitan Haim, was actually indicted and was on his way to be prosecuted for criminal HIPAA violations after he acted as a whistleblower on a local hospital that he worked with in Texas. His whistleblowing activity involved claiming that the hospital was continuing providing gender-affirming care to children while it had publicly said that it had stopped providing gender-affirming care. And actually, Texas, following that issue, banned gender-affirming care completely by legislation from the Texas legislators. So the Department of Justice continued to prosecute this poor physician, surgical resident, excellent physician, Dr. Eitan Haim. They continued to prosecute him, and it wasn't until the new administration with the new president decided to actually dismiss the indictments with prejudice, something that happened a few days ago, that he was set free, but he was facing a criminal trial for HIPAA violation where he was destined to spend 10 to 15 years in jail for no release of any personal identifying information, no issue with any patient privacy being violated. It was just that he was whistleblowing about what he perceived as inappropriate things that were being done by the hospital. So the criminal prosecutions are for us, and hospitals and health insurance companies don't even get a slap on the wrist.
What are some things that physicians can do, obviously, to avoid criminal prosecutions as it relates to HIPAA?
So education. Physicians need to educate themselves. There is online free courses on HIPAA from all of the professional organizations. For example, my professional organization, the American Psychiatric Association, the American Medical Association, they have online courses about HIPAA. They need to educate their staff about HIPAA, and they need to have a robust safety system in terms of being able to maintain the privacy of patients. However, there's a movement now with independent physicians who are seeing a movement from patients not wanting their health information housed on health medical record systems that are of large hospitals like Epic. So the patients would gravitate toward private physicians that may have private electronic medical record systems or even paper records. There's still some physicians who maintain paper records despite the penalties, and there are some patients who are asking physicians to go back to paper records. Please don't maintain my data out there on the web. I want my medical records to be on paper. I have several patients who request that. VIP patients, individuals who are even in law enforcement, and prosecutors and judges and lawyers who are patients of mine who say, please don't keep my data on an electronic medical record. Just I do paper records, and if somebody asks for my records, you should ask me before you release my records to anybody. So that is a dangerous precedence that we're going back. HIPAA was supposed to facilitate electronic medical records, and now we're having patients going back to paper medical records.
We're talking to Muhamad Aly Rifai. His Kevin MD article today is The Criminal Enforcement of HIPAA. Muhamad, as always, let's end with some take-home messages that you want to leave with the Kevin MD audience.
HIPAA is a law that protects the privacy of our patients and their medical records. We need to be well educated about that. It is a well-intentioned law, but unfortunately, its administration and basically the fact that it has become something that's not helpful to our patients, it has led to significant breaches in electronic medical records. And we need a recalibration of the law, and hopefully the new administration will try to streamline and simplify some of these regulations that have not been helpful to our patients.
Muhammad, as always, thank you so much for sharing your perspective and insight, and thanks again for coming back on the show.
Thank you very much for having me.